Gaming Act 1845. The Gaming Act 1845 8 and 9 Vict, c. 109 was an Act of the Parliament of the United Kingdom. The Act's principal provision was to deem a wager unenforceable as a legal contract. The Act received royal assent on 8 August 1845. Sections 17 and 18, though amended, remained in force until 1 September 2007. Background. Increasing concern as to the damaging social effects of gambling gave rise to a select committee of the House of Commons whose recommendations were implemented by the Act. The policy of the Act was to discourage betting. However, following a 2001 report by Sir Alan Budd, in 2002, the UK government accepted that wagers should cease to be unenforceable as contracts, seeking to introduce a new liberalised regulatory regime in order to encourage the gambling industry. Repeals. Sections 1 to 9 and 15 and 16 and 19 to 24 and 26 and the first and second schedules were repealed by part out of Schedule 6 to the Betting and Gaming Act 1960. Sections 10 to 14 and the third schedule were repealed by Section 1 of and a Schedule 2, the Billiards Abolition of Restrictions Act 1987. Section 25 was repealed by Part Roman 19 of Schedule 1 to the Statute Law Repeals Act 1976. This Act was repealed for Northern Ireland by Article 187 and Schedule 21 to the Betting, Gaming, Lotteries and Amusements Northern Ireland Order 1985 SI 1985/1204 NI 11. The whole Act was repealed in the Republic of Ireland by the Gaming and Lotteries Act 1956. Exclusion. This Act was excluded by Section 16 of the Gaming Act 1968. Section 1 Repeal of part of the Unlawful Games Act 1541. Section 1 Repeal the Unlawful Games Act 1541 33 and 8c9 as to so much whereby any game of misskill, such as bowling, quoiting, cloche-kills, half-bowl, tennis or the like, was declared an unlawful game, which enacted any penalty for playing at any such game of skill as aforesaid, which enacts any penalty for lacking bows or arrows, or for not making and continuing butts, which regulates the making, selling, or using of bows and arrows, requires the mayors, sheriffs, bailiffs, constables, and other head officers within every city, borough, and town within the realm to make search weekly or at the farthest once a month in all places where houses, alleys, plays, or places of dowsing, codding, or gaming shall be suspected to be had, kept, and maintained, as makes it lawful for every master to license his or their servants, and for every nobleman and other having manors, lands, tenements, or other yearly profits for a term of life, in his own right or in his wife's right, to the yearly value of £100 or above, to command, appoint, or license, by his or their discretion, his or their servants or family of his or their house or houses to play at cards, dice, or tables, or any unlawful game. It provides such commandment, appointment, or license shall not avail any person to exempt him from the danger or penalty of playing at any unlawful game or in any common gaming house. Section 15 Repeal of other laws. Section 15 repeals the following: Gaming Act 1664 16 Shaw. 7 Gaming Act 1710 and c. 19 as was not amended by Gaming Act 1835 5 and 6 will. 4c. 41 Gaming Act 1744 18 Geo 2c 34. 19 Ind. Asterisk as renders any person liable to be indicted and punished for winning or losing at play or by betting at any one time the sum or value of £10. Section 17 Cheating at play. This section created an offence. At the time of its repeal, this section read: the words of the enactment at the start were repealed by the Statute Law Revision Act 1891. The words in square brackets were substituted for the words "be deemed guilty of obtaining such money or valuable thing from such other person by a false pretence, would intend to cheat or defraud such person of the same," and being convicted thereof shall be punished accordingly by sections 33 and 36 of and Part Roman 3 of Schedule 2 to the Theft Act 1968. £200. Section 32 of the Magistrates' Courts Act 1980 provided that the reference to £200 was to be construed as a reference to the prescribed sum. The following cases are relevant of E. Dolly 1826 1 Stark NP 359 1826 170 1 E of 497 Cut v Stratford 1844 13 M and W 379 1844 2 Dow and L 399 1844 4 at OS 138 RV Hudson 1860 Bill CC 263 RV O'Connor and Brown 1880 145 LT 512 1880 146 JB 214 1880 115 Cox 3 RV Mower 10 CR Appar 54 CC RV Lawler 14 JB 561 LV Governor of Brixton Prison Export Esterland and Metzler 3 KB 568 2090 LR 10 77 JP 23 RV Leon KB 136 30 CR Apo 120 61 TLO 100 CCA RV Butler 38 CR App R 57 CCA RV Klukas and Derek 1 WLR 244 1 All ER 438 43 CR App R 98 123 GB 203 CCA RV Harris and Turner 2 QB 442 2 WLR 851 2 Ball ER 294 47 CR Apple 125 CCA. In 2005, Quangley, Martin Fitz and Schuhelmeyer were found guilty of cheating at roulette under this section. Section 18 Gambling Contracts deemed void. This section concerned whether unpaid winnings accrued from gambling could be sued for in a court of law. The Act made it clear that they could not because winnings from gambling were to be treated as a debt of honour and as such could not be treated as a financial debt. The Act read, quotation, all contracts or agreements, whether by parole or in writing, by way of gaming or wagering, shall be null and void, and no suit shall be brought or maintained in any court of law and equity for recovering any sum of money or valuable thing alleged to be won upon any wager, or which shall have been deposited in the hands of any person to abide the event on which any wager shall have been made, provided always that this enactment shall not be deemed to apply to any subscription or contribution or agreement to subscribe or contribute for or towards any plate, prize, or sum of money to be awarded to the winner or winners of any lawful game, sport, pastime, or exercise. This section was extended by the Gaming Act 1892. However, a bet on the horse race Totalisator Board, also known as the Tote, did not fall within the scope of the Act. Further, by the 1980s, it was feared that complex commercial risk management instruments and contracts such as derivatives could fall foul of the Act. Provision was made that a contract would not be void if at least one of the parties entered into it for legitimate business purposes. The exemption is now found in the Financial Services and Markets Act 2000 S 412. The Gambling Act 2005 removed the debt of honour clause that made gambling winnings exempt from legal action if they were not paid. This meant that unpaid winnings could now be pursued in a court of law. Section 19 Feigned issues abolished. Court of law or equity that desired to have any question of fact decided by a jury had it presented in the form of feigned issues, by stating that a wager was laid between two parties interested in respectively maintaining the affirmative and the negative of certain propositions. It was enacted that in every case where any court of law or equity desires to have any question of fact decided by a jury, it should directly state the question of fact in dispute, with such persons being plaintiffs and defendants as the court may direct, rather than as a feigned issue of a wager. Ireland and Northern Ireland. The Act was in force in Ireland until partition. It consequently became the law of the Irish Free State on 6 December 1922, and then of its successive states until its repeal in 1956. When the autonomous region of Northern Ireland seceded from the Irish Free State and rejoined the United Kingdom on 7 December 1922, the Act became the law of Northern Ireland until repeal. Cases. Clause v. Wilson UKCIV 5, a promise to money paid under an agreement to bet cannot be enforced because of the Gaming Act 1892 S1, but the payer has a claim in restitution for the winnings and for any money used for purposes other than betting.